August became the rule of law. What rights do you have? What does the Constitution
Activates the power of the people. Join me, Consolata Chibalonza, every Wednesday at 9 p.m. on Know Your Law, only on EBN TV.
The 2010 Constitution, as of the 27th of August, became the rule of law. What rights do you have? What does the Constitution provide? What chapter? What article? What act?
Know Your Law grants you knowledge and activates the power of the people. Join me, Consolata Chibalonza, every Wednesday at 9 p.m. on Know Your Law, only on EBN TV. Good evening once again. My name is Consolata Chibalonza and we are live here at EBN TV. We are live across all the social media platforms on EBN TV. The show is Know Your Law. For questions, comments, commentaries and everything you'd want to say about the show, hit us up on EBN TV across all social media platforms, and it will be my joy and honor to share them live here from the studios. Now, today we're talking about employment. It is a discussion we started last I think 2 weeks, if I'm not wrong, and we are still on it. Indeed, we know we need to understand what we have as employees, as employers, and with me is none other than Wakili Phillips Matata. I hope I'm saying his name right, and if I'm not, he's going to introduce himself and tell us his name, what he does, and from there on we shall see how this conversation will flow. Good evening.
Good evening.
Welcome.
Thank you for hosting me. My name is Philip Matata, as you've said. I'm an advocate of the High Court of Kenya, and I practice in employment law, criminal law, constitutional law, and other legal practices.
Yeah, that is interesting.
Yeah.
So, just to ask a very personal question, for how long have you been practicing?
I was admitted in 2021, so this is my third year since admission.
Okay, and how has it been for you?
It's been good. It's been good. The experience has been good, helping some vulnerable people in certain situations. It's been a good experience, if I can summarize it.
Yeah. And is it something that you saw yourself doing from day one? Like since you were young, you just wanted to be a lawyer?
I think, yeah. I remember when I was in class 6. Some of my colleagues, or you know, when you're in class 6, everyone says, "I want to be a doctor, I want to be an engineer or a pilot."
Yeah.
For me, I just wanted to be a lawyer from that young. Yeah.
Okay.
And I'm glad it's come to fruition.
Is it really hard studying?
For me, I think everything is all about. It's all about passion. You know, something becomes hard if you meet an engineer and you ask him whether engineering is hard. He'll tell you it's not hard, but for somebody like me, it's something difficult because it's something I'm not that passionate about. So when you're passionate about it, you want to learn more about it, and it works well for you. Okay. Yeah.
Okay, enough of the personal innuendos. Now let's get straight to what brought us here. Now today we are doing employment. And number one, I would love if you can help us, please try to define the types of employment that we have.
So first of all, I'll start by defining employment.
Yeah.
Employment in general. Employment is a relationship between an employer and an employee for provision of services. Let's say somebody has employed you let's say somebody has been employed something like human resource department. So you're providing that service to the employer. So it's all about that relationship. And within that relationship as employment, there are two types of, there's casual employment and there's permanent employment. Okay. Yeah. So casual employment is a kind of employment where somebody is paid daily for the services that he's done. Then permanent employment is where somebody is employed for a long period of time on a permanent basis. And in most cases, the contract defining the terms of engagement are usually written. Yeah, as
in a contract.
Yeah, in a contract. They are written there in most cases. Though a contract, an employment contract can arise orally or in written form. Yeah, you can just agree that from next week we engage. Then I tell you from next week maybe you'll be providing these services for me. You'll be carrying maybe some goods from Gikomba. Then maybe let's say somebody who's selling this Mtumba merchandise. You'll be bringing the Mtumba merchandise to my shop every day. So that's an oral agreement. You've not written it. You've not reduced it to writing, but the written one is where there's a contract defining, like, for this contract you are employed, this is your role. It defines your role within the arrangement. Like your role will be maybe moving. Let's say a company that works with parcel. Your job will be transporting parcel from here to Mombasa Road. You'll be working from 8 p.m. to 5 p.m. So those terms within which people work are defined by a contract. Yes.
Okay. So when we talk about the oral contracts, before we can even continue with whatever you're doing, well, the last time we had somebody also come here and talk about the importance of a contract. So I don't want us to go again towards that. But when you do the oral contract, can you take it to court and be like, he said, she said?
Yeah, I get the question. Yeah, that's a very important question. So although oral contracts can be taken to court, but this is a court of law and it's based on evidence. So when you go before the court and you tell the court, maybe you tell the court that I've been employed, it will be your word versus my word before the court, and that will not suffice. It will be difficult for you to prove that there was an employment relationship. You'll have to bring witnesses to confirm that. So to avoid such a situation, it's prudent to reduce all contracts to writing, so that when there's an issue, maybe you go to the court, they'll say the contract will stipulate, like, these are your roles, and these are your duties. So whenever there's a disagreement regarding the contract, now the terms will be defined. You'll see, this is my role. Did I violate any terms of employment? If you did, as in the contract will say whether you violated based on what's there.
Okay, so how does one get to create this contract?
The contract of employment is usually like you're asking how
do you create? How do you write? How do you formulate?
Mostly it's the employer. It's the employer who is under duty to because you cannot be employed and then you come with a contract defining like in an employment relationship is like the employer is the boss in that relationship. So it's just guards to ensure that the employee is not, his rights are not violated. So in that case, the employer is the one who's going to define the terms and conditions of employment, maybe, but before maybe we'll talk about now later, the requirements, or you'll want me to?
No, you can just do it even now.
Even now? Yeah. So as in, although an employer is required to draft the contract, the contract must align with the law. The contracts must align with the law. There are some duties that are required of the law of the employer and employee. So like you cannot, first of all, let's say for example, an employer is under duty to provide fair remuneration. There's a limit in which somebody is supposed to be paid in Kenya. It's around, I think, 13,000.
13,000,
So an employer cannot write a contract, then say, we agreed on this, then he pays the employee 10,000. You see, even though the employer is under requirement to draft the contract, he cannot draft it in such a way that it does not align with the law. Then let's say there's a requirement under Article 141 that an employee must be given, even in the Employment Act, must be given reasonable working conditions. So you cannot draft a contract that requires an employee to work in an unsanitary or a dangerous situation, let's say mining, without providing a safe working condition. So even though that agreement will be between the two of you, it will not be valid because it violates the law. So a requirement is that it must align with the law.
With the law.
Yeah.
So let's get to the employer's side. Let's now talk to an employer who is listening to or watching us right now.
Yeah.
When it comes to drafting or employing someone, for example, we know the law stipulates I can't pay you below 13,000 Kenyan shillings, but according to my business, and I've done my due diligence, I've audited myself, and I know if I say I'm paying you 13,000, I will not hold, but I'm willing to pay you 10,000. What provision is there for me as an employer? I want to give out these jobs, but I do not meet that threshold.
That will be, you know, the law stipulates the minimum wage.
Yeah.
The minimum wage. So, like the minimum wage upon which the employee should be paid, like 13,000.
Yeah.
So you cannot go contrary to a legal provision that provides the. In fact, there was this issue about house helps.
Yes.
Yeah, some people, and that's a lacuna within the law. Maybe that should be addressed.
Yeah.
Because there are some people who are paid 16,000, and then you need a house help, and so sometimes that's where sometimes the law has some gaps.
Okay, so it's not provided for.
Yeah,
like there's no provision for that.
Yeah.
You just pay 13,000. Even if I'm the one receiving 13,000 and I have a little girl at home and I need a house help, I need to get 13,000 for the house help.
Yeah, because that will be like violating a specific legal pronouncement.
All right, so let's continue. How can a contract of employment be terminated? What are the options I have as an employer? Because right now I want us to focus more on the employer than the employee.
Than the employee.
Yeah. So how can I terminate a contract?
You're terminating a... Okay, first of all, there are ways in which a contract can be terminated without specifically either the employer terminating or the employee terminating. For example, when somebody dies. When somebody dies, then that contract will be terminated by operation of the law.
Yeah.
Then the second way is redundancy or retrenchment. You know, like we look at redundancy to explain it. Is when your job is not required. Your services, like the specific scope of your job, like is not required by the employer.
Okay.
Yeah. Let's say during COVID-19, some companies found it challenging to retain some employees, so they had to downsize. And so there are some components of the job that were deemed not necessary given the economic conditions. So some employers decided to reduce the number of workers. So that's one way in which you can terminate a contract, and there are specific provisions within which you can terminate that contract. Yeah, like for redundancy, you don't just say that it's too expensive or this job is not. Then you say, oh, we've terminated your contract. In the case of redundancy, first of all, you'll go to a labor officer. You'll report it to the labor officer at least a month. You notify the labor officer that because of this and this situation, I need to reduce or to do away with this job. So you first notify them. That's a requirement of the law. If once you've done that, you'll have a sit down with the employee, because employment is more like a relationship. It's somebody depends on it, so it's more like a relationship. So you'll have a sit down with him. You talk to him. You inform him that, hey, these are the reasons why I want to do away with this. To do away with this contract, to terminate your services. Then once you've agreed, once you've agreed to terminate the contract because of redundancy, then you'll have to pay him. So you'll not just say that once you've terminated it, you'll pay him. First of all, if you didn't give him 1 month notice, you'll pay him in lieu of notice, payment in lieu of notice. Payment in lieu of notice is generally paying somebody because you didn't notify them, because they had legitimate expectations that at the end of the month they're going to pay, and maybe they entered. So you have to pay them 1 month in lieu of notice. Then secondly, you have to pay them severance pay. So severance pay is like you're severing the contract. You're severing, so you have to pay them. And the severance pay is calculated. You have to be paid an equivalent of 15 days salary for the amount of years you worked. Let's say for the amount of years you worked.
Okay.
Assuming you paid 100,000 a month, so you have to calculate. Let's say you're paid. Let's give an easy to calculate some 90,000. So per day, it's assumed you paid.
So it's 90,000 divided by 30.
That's 30,000. Yeah. 90,000. No, per day. I'm calculating per day now. Yeah, 3,000 per day. So 3,000 you'll multiply by 15.
Okay.
By 15.
That's 45.
Yeah, that's 45. Then if he's worked for 6 years, that will be like 90,000. So that's severance pay.
Well, okay.
Then payment in lieu of notice. Then the law stipulates that a person is entitled to leave, to annual leave.
Yes.
So there are some employers maybe for the last, like maybe for 6 years in this case, maybe he hasn't been paid annual leave, which every employer is entitled 21 days, an equivalent of 21 working days, not just days, working days. Like if you work from Monday, it's 21 working days. So if you haven't paid them for 3 years, now you'll pay them that amount for the 3 years that they've worked for you.
What?
Yeah. So that was one way of terminating a contract. Then the second way in which an employer can terminate a contract is through dismissal. So when you talk about the dismissal, there are two types of dismissals. There's a normal dismissal, then there's summary dismissal. So let me differentiate the two of them. Yeah, a normal dismissal is when probably, let me give an example that will work with the viewers. Let's say, for example, somebody has been coming late for work consistently.
Yeah.
So an employer finds it hard to work with them.
Yes.
So that's a normal dismissal.
Yes.
Like they'll have a sitting and all that. To ask him, they'll give him warnings. Maybe they've given him warnings. He should be coming early and all that. Then he's not followed the rules. So he'll be given a sitting to explain why he's been coming late. Then the contract can be terminated. That's a normal dismissal. Then there's this summary dismissal. Summary dismissal arises where somebody has been has violated, it's a serious violation of the terms of employment. Let's say somebody comes in drunk, somebody steals from the employer. Yeah, so they'll be summarily dismissed. Summary dismissal refers to where an employer can terminate your contract immediately or giving you a notice that is less than would be required. Maybe the term says, I'll give you a note, I'll notify you, maybe respond to this, you violated this term, I'm giving you 7 days, like the one for coming late. You'll be given 7 days, you'll marshal up your evidence, then come, then explain why you've been coming late. But in this case, you've stolen from the employer, he can just terminate your services or give you 3 days within which to respond. Then he can terminate your employment summarily. So but then with summary dismissal, then there's a whole requirement in which now the hearing for the normal dismissal, now the hearing will be conducted. There are some requirements stipulated by the law in which an employer must abide by when terminating a contract.
If for instance, my contract has been terminated via dismissal.
Yeah.
Can I contest it if I feel it was not done rightfully?
Sure. You know, a contract dismissal, an employer cannot just terminate somebody's contract. There must be substantive they must follow substantive, there must be substantive and procedural reasons. Substantive reason refers to, it must meet, substantive reasons refers to situations where maybe you've been coming late. So there's a reason within which, the substance within which you've been terminated. But the fact that you've been coming late does not give the employer the leeway to just terminate your contract. They must follow some laid down procedures. That's why you see you're given a show cause letter, first of all. They notify you that there's some infraction, you've not abided by the terms of the contract. So you'll be given a show cause notice. The requirements of show cause why your contract will not be terminated is that they give an employee a fair opportunity within which to defend themselves. So employers, this is just an advice. You just don't dismiss. You first of all give them a notice.
Yeah.
Then with the notice, you don't give somebody like a notice maybe today, then you require them to respond tomorrow. You give them adequate time within which to respond. So the notice must give specific reasons why the employer intends to terminate your contract. Then they give you time within which to respond. Then, having given you time, they'll give you a right. You have a right to fare. The employee has a right to maybe bring an advocate or their colleague to support their case. And if they belong to a labor union, they have a right to bring a member of the labor union to represent them during the hearing. Then the hearing, like all other hearings, must be fair. So those are the requirements. There must be fair hearing before dismissing somebody. And fair hearing, it's just like a normal thing. Like you can't, maybe for an instance, you can't let somebody who was actively involved in the process that led to somebody termination to be among the people who hear the matter. Yeah. So it must be a neutral arbiter. It must hear the matter. Then once you've terminated them, you must give them the reasons why you've terminated them. Maybe, yeah, these are the reasons. We have evidence of this and this and this, and that's why we've terminated you. And even having given them reasons, you still give them a right to appeal. Yeah, so they can appeal if they feel aggrieved with the decision. They can appeal. They can appeal and say, maybe the decision was not right, so they'll be given a right to appeal. Once there's an appeal and the decision is maintained, the termination will be final. Maybe now at this point, now they can move to court or other avenues.
So once my contract has been terminated, that means the relationship between me, once I terminate a contract as the employer, does that mean the relationship between me and the employee is done?
Yes. Yeah, it's done. There's no further employment, there's no further relationship, but then there are some things. It doesn't end per se it depends with the reason. Like just say, it depends with how the contract was terminated. But essentially, the relationship will have been severed, it wouldn't be there. But now, maybe there will be some requirements of the employer, or maybe to make good of the employee, like to pay them some amount of money, depending on how the contract was terminated. Yeah. Okay. Like let me go back to like redundancy. No, like when the contract is terminated, maybe the employer is entitled to certain things, even a certificate of service.
Oh, okay.
Yeah. So certificate of service is like acknowledging this employer has worked for me for like this period. It indicates he's worked in our company for this and this period. Yeah, and he worked in this capacity and all that, so that at least it's giving him an opportunity to use maybe the fact that they worked with you. Yeah. So when they are employing, maybe for their CV and all that. Yeah.
Okay. So thank you. And we are finally coming to the end. I do not understand how time flies during this show, honestly. But what is it that you would want us to hear from you as we bring this show to a close?
Yeah. Maybe this is maybe to employees. Okay. Employees, if your contract is being terminated, some employees are given an opportunity an opportunity to defend themselves. And sometimes, you know, the working conditions in most employments, maybe the working environment is not conducive, and maybe you feel like this person is just targeting me. And then you are invited to appear before the hearing. You are given a show cause notice, then you are told appear on this and this date for the hearing. Please, employees, even if like you feel the process will be unfair, you just need to attend the meeting. You just need to attend, because when it goes to court, the employer will say, I gave them an opportunity to defend themselves, but they didn't come. So just attend the meeting. And if you're given an inadequate notice, some employers do that. They become technical with the whole arrangement. They give you inadequate notice. Maybe you can do a letter. Let it be written. Do a letter or an email. Have evidence that you follow the procedure. Say this notice is short. I cannot attend. Preferably, maybe you can give me 1 week. So when you go to court, if at least you'll have evidence that you're given an inadequate notice and all that. So I think that's something that employees can use to defend themselves when they face such situations.
Wow, thank you very much, Philip Matata. It was an amazing session. I assure you, you're coming back again.
Thank you very much, and it's a pleasure appearing before this show.
Thank you so much for showing up. Maybe when you come back, we'll touch on your criminology side and maybe see what we can do about that. But for now, that is all we had for you on Know You Law. My name is Consolata Chibalonza. A lot has been said by Wakili here, and I do hope and believe that you took what's yours and you're running off with it. The discussion is still going on across our social media platforms, that is EBN TV. If you're seeing this for the first time, then know every Wednesday we do have a Wakili on board here to help us know what rights do we have, how can we fight for the little things that we have, how does the Constitution of Kenya stand for us. That is your opportunity. If you have a topic you think we should discuss, also let us know on the comment section, whether you're watching us on FB or live on our website, that is www.ebn.tv, or you are watching us from YouTube. Please, wherever it is, do comment, and we assure you we will get back to you. Thank you very much for your time, and until next time, God bless.
Thank you. It's a pleasure.
The 2010 Constitution, as of the